This is Keith Davidson from Albertson & Davidson. In this video, I want to discuss what do you do if you have a trustee who vehemently opposes doing what the trust terms tell the trustee to do. Unfortunately, this happens all too often where a trustee will be acting, and usually it's a trustee who isn't a professional because they don't understand their duties as trustee, and they simply refuse to follow the trust terms. The trust may say that they have to make distributions, or they have to let somebody live in a home, or they have to give somebody the right to buy a home, or any number of things that trust can say, and the trustee simply refuses to do it. And so that's when oftentimes we'll get a call and somebody wants to know, what can I do? The first thing you need to do is get yourself a good lawyer because you're going to be going to court. The only way to enforce a trustee's duties, to force them to do the right thing, is to take them to court. You file a petition in probate court, and you ask the court to order the trustee to act, or any number of other possibilities. There's a lot of things you can ask the court for, but you must do it in court. There's no other governmental agency that's going to help you or that oversees trust. It's up to you to take the action to enforce the trustee's duties. A lot of times people will ask, well, isn't what the trustee is doing, isn't that illegal? And it is in the sense that they're going against their fiduciary duties as outlined in the trust document and the probate code, but it's not illegal in a criminal sense. So you're not going to be able to go to law enforcement or the district attorney's office and expect that they're going to do something for you. It's not illegal in that sense, the way robbing a bank is illegal. But a trustee can breach their duties that they're required to follow under the probate code. And there's a remedy for that. And that remedy is for you to go to court and force the trustee to do the right thing. The second thing you need to do is you need to consider what actions do you want to take once you're in court. And I'm going to read from Probate Code section 16420. And these are what we call the remedies. And remedies is just a legal term for the actions the court has the right to take to try and fix your problem with the trustee. So under 16420, the court has the right to order the trustee to perform the trustee's duties. So for example, if the trustee is required to make a specific gift to somebody of $500,000, the court can order the trustee to do that. The court can also order the trustee to not take an action. So for example, if the trustee wants to sell a house that's supposed to go to one of the beneficiaries specifically, the court can order the trustee not to make that sale. The court can order the trustee to pay back money to the trust or to take other actions to reimburse the trust for any losses. The court can appoint a temporary trustee or a receiver to take possession of trust property and manage it pending the outcome of a lawsuit. The court can remove a trustee. The court can set aside acts of the trustee that have already occurred. There's some limitations on that, though, and you can't necessarily set aside everything that's occurred, especially sales of real property to a bona fide purchaser. That cannot be set aside. But if it's some other transaction, like the trustee bought a house from the trust for themselves, that's the type of thing that the court could set aside if the judge decides to do that. The court can trace trust property that's been wrongfully disposed of or taken. The court can reduce or deny compensation to the trustee so they don't get paid for their duties. And the court can also impose an equitable lien or constructive trust on trust property, which means whoever does possess it has to hand it over to the rightful beneficiary. So that is a list of items that the court has the power to do. It doesn't mean that it's necessarily easy to get the court to do those things. You have to show evidence for why you deserve one of those remedies. And the court has to be convinced that one of those remedies is a good idea and will fix the problem. So just because you think a trustee should be removed doesn't mean a court is going to agree with you unless you have sufficient evidence to remove that trustee. And that brings me to the third thing you need to do. Once you hire a good lawyer and you figure out what remedies you want to ask the court for, the third step is you have to build your case. So that means you have to go out and find the evidence that's going to convince a judge that they should give you the remedy that you're asking for. And so again, for removal, you need to show evidence as to why this person should be removed. If you want a transaction undone, you have to show evidence that it was an improper transaction to somebody who was not a bona fide purchaser. So maybe a real property was sold to the trustee himself. That would be an example of an improper conflict of interest. And it's the type of sale that possibly you could get set aside if you have the proper evidence. If you think the trustee has stolen money, just taken money and put it in his own pocket, then you have to go out and find that evidence, which usually is found in bank records and things of that nature. So you have to build your case. You can't just go to court and ask the judge to start issuing orders unless you support those requests with admissible evidence. So it's not that easy in every case to hold a trustee liable for the wrongs that they're doing, but it is possible, and some cases are easier than others. The bottom line here is if you're dealing with a bad trustee who's doing all the wrong things, you need to take action, and you need to take action as quickly as possible, because the longer you wait, the more damage that trustee will do to your trust. Albertson & Davidson is here to help you fight for your inheritance. Check out aldavlaw.com for our complete library of helpful legal videos and articles from your favorite California trust and will litigation law firm, Albertson & Davidson, LLP.